All rise for the Field Division 1 is now in session.
Good morning. Please be seated. This is the time and date set for CV220746, Markham Contracting Company versus Cahava Springs Phase 1 Incorporated. These proceedings are being audio and video recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to argue. Appellant's counsel is responsible for reserving any portion of that time for rebuttal if you so choose. Also, we've read the briefs. We've discussed this case in conference. We're familiar with the facts. Bear that in mind during your presentation. At this point, counsel, are you ready?
Yes.
Please proceed.
Good morning, Your Honors. May it please the Court. My name is Eric Frazier. I represent the appellant, Markham Contracting. This is a case about a group of landowners who set everything in motion. They set up a district for the purpose of benefiting their property. They specified exactly what work should be done. They expressly consented in writing to the district contracting out that work, and they agreed to ultimately fund that work via assessments on their property. They even specified how to apportion those assessments on each individual lot, which means that they intended to pay for this infrastructure work and have never explained how they expected not to have to pay. But they reap the benefits of this work. They even agreed in writing in the development agreement that this specific work will benefit their own property. That is unjust enrichment. The landowners received a benefit, and it would be unjust to allow them to keep that benefit without having to pay for it. Section 25 of the third restatement addresses this exact situation, where you have an unjust enrichment claim that arises when a third party breaches a contract. Some of these types of claims are viable, and others are not, and the difficult question is how to sort between the viable and the non-viable claims. That's exactly what the third restatement does. It provides a comprehensive, useful framework that courts can apply when they're faced with a situation like this to determine whether the claim can proceed.
Is there a requirement under the third restatement that there be some improper conduct?
There is not, Your Honor, and for good reason, because
I thought, it seems like I remember from the reply brief there was a reference to a section 2.4 that inserted the word innocent, that if it's not an innocent, I don't know if that came from the comment, the restatement, but I'm sorry, I interrupted you.
No, I'd love to hear your question. So wrongdoing simply is not required. Improper conduct is not required. The Louiselle v. Costas management case says that it allows for an unjust enrichment claim even if the defendant did not act tortiously or wrongfully. The section 2.4 in the third restatement, it's talking about the forced exchange concept and the innocent recipient. That is getting at the concept of volunteer, meaning that the mischief that is trying to avoid is the situation where you have a landscaper who drives by a neighborhood, starts mowing people's lawn, ringing the doorbells and saying, I just mowed your lawn, here's my bill. You don't want to subject people to a situation where they are buying something, they're forced to buy something, forced into an exchange that they never wanted, would not have selected this person, didn't want to pay for it, didn't want to pay that price. It's the volunteer concept that you're trying to avoid. Section 25 addresses exactly how you deal with this situation, where there's no question Markham was not a volunteer. We were not going out there and doing work that nobody asked for. The district, of course, asked us to do this. We had a contract with the district, and so Section 25 addresses the situation where you have a third party, here the district, that breached the contract with the claimant, Markham, and now the claimant, Markham, is suing the owner, the recipient of that benefit for unjust enrichment. And so Section 25 deals with that forced exchange concept that is in Section 2. It even references Section 2.
But under the contract, I mean, you guys have been through an arbitration here, right? And there was an arbitration award, a judgment entered. I mean, so why
go down this path? I want to make sure I clearly understand why you haven't already resolved the breach of contract issue that you're complaining about.
Well, we're complaining about unjust enrichment now, and the reason why the arbitration award doesn't resolve this is because we haven't been paid a penny on that award. And the reason we haven't been paid a penny on the award is because the district has no money. The reason the district has no money is because the landowners have not paid the assessments that they agreed to place on their land, that they agreed to pay. Because the landowners haven't paid those assessments, the district has no money to satisfy the judgment. And so this section 25 of the third restatement addresses those situations where, for whatever reason, the contractual counterparty has not paid.
So what's the benefit that they've gained other than obviously the infrastructure that was put in by your company that was gained, but I mean, is there some other benefit that we should be aware of?
That is the benefit. This is essentially raw land, and it's not developable if people can't get to it, if there's no water to it. So this was very critical infrastructure work, building a roadway, building a water line, doing landscaping, things that unquestionably benefit their property. That's the benefit, and those are the benefits that we are seeking compensation for.
So is it still raw land that is not developed?
I think that's right. That's not in the record, but I think it's still undeveloped.
So that's the question I go back to is, yes, the infrastructure is there, but what is the benefit until the land is actually sold?
Because, again, well, first of all, we don't need to resolve that question here because the landowners in the development agreement expressly acknowledge that these benefits, that they are benefited by at least, or an amount not less than the value of the assessment. So they are agreeing in writing in the development agreement that this specific infrastructure work provides their land a benefit. And we know that because if you sell raw land that doesn't have a roadway leading to it, doesn't have a water supply, it's going to sell for a lot less than land that does have a roadway leading to it and does have a water supply.
So would we still be here if they had paid that arbitration judgment?
No.
Thank you.
I'd like you to address this. Both sides spent a lot of time addressing Wang and Arrow, and we're arguing restatement third versus first. How do we get over Justice Timmer's assertion that there has to be improper conduct, and explain your perspective on that issue?
Sure. So I can address this in a few different ways. I think the easiest path for the court is to limit Wang to the context in which it arose and to the plain text of the decision, which is tenant improvements. Wang did not purport to announce a bright line rule that improper conduct is required in all unjust enrichment cases. And this court clarified that in the Beauchamp case, or Beauchamp, however you want to pronounce it. The court did not impose a new improper conduct requirement in all cases. And the Colorado Supreme Court, where Wang borrowed the rule from, that court has since again clarified that this only applies to the tenant improvement context, which makes sense because the law is particularly concerned with imposing liability on landlords for tenant improvements, because courts, I think, recognize that the reality is a lot of tenant improvements are unilateral, and they're almost always the result of a bona fide arm's length relationship between the landlord and the tenant. So the tenant requests the improvements. There's an actual arm's length transaction between the landlord and the tenant. Here, we have nothing of the sort. This is not an arm's length transaction. There is complete overlap between the landowners and the district in terms of control, people. And I think the best illustration of that is Mark Stapp signed the development agreement between the landowners and the district on behalf of every one of the landowners, and then 2 weeks later signed the contract between the district and Markham on behalf of the district, which again was his contractual counterparty 2 weeks earlier. But in terms of Wang, the decision itself suggests it's limited because when it identified the issue in the case in paragraph 12, when it quoted the holding from DCB in paragraph 14, when it articulated its own holding in paragraph 15, and when it summarized its holding in paragraph 17, every single time it referenced tenant improvements. things that are requested by the tenant. And it makes sense that you wouldn't have to find improper conduct in every case. Because again, the central question in an unjust enrichment claim is not whether there was wrongdoing. The law does not require wrongdoing. Again, that's the Louiselle v. COSIS management case that we cited in our briefs. The question is, were there benefits? And is it unjust to let someone keep those benefits without having to pay for them? And Wang is, again, kind of a peculiar case because it was decided after the third restatement, very, very soon after the third restatement, and apparently nobody in the case alerted the court to the fact that the third restatement existed.
Now, can we draw that absolute declarative statement, or do you think the court could have just disregarded the third restatement entirely?
It could have disregarded. It had the power to disregard it. There's nothing in the opinion that suggested that it consciously disregarded it. And so I think there is absolutely no problem with this court saying, as it did in Beauchamp, that that Wang is limited to the tenant improvement context, and that the third restatement controls, for the case that's in front of us today. And again, the unjust enrichment is a flexible, equitable doctrine, so it doesn't make sense to have bright line rules that would exclude a whole category of cases where you have this situation where the claimant had a contract with a third party, that third party breached the contract, now the claimant is going after the party that received the benefits. Those cases, other than Wang Electric, do not require improper conduct or any kind of wrongdoing on behalf of the defendant. That's just not a court.
You're suggesting, I assume, this is similar to the cases involving a general contractor and a subcontractor, and in those situations, if the owner has paid the contractor and the contractor doesn't pay the sub, then we don't go after the owner. I think that's the line of cases Wang talks about.
Yes. So if I want to make sure I heard you correctly, if the owner has not paid the general contractor, we do allow the contractor to go after the sub, or the contractor to go after the owner. If the owner has not paid anybody, then I'm sorry, vice versa. If the owner has not paid anybody, there is a claim. If the owner has paid somebody, then there's no claim. And here the landowners have not paid the assessments. They have agreed to put assessments on their land. They've agreed to pay assessments to a government entity and have not paid. The government entity has not collected them. And I think the reasonable inference is the only people who would stand to benefit from the district not collecting the assessments that it unquestionably is owed are the landowners. They're in control of the district. So they're not paying, they haven't paid the assessments, and they haven't given any explanation for failing to pay the assessments. They haven't given any explanation for how they expected not to have to pay for these improvements. The district contracted out the improvements. They set up a funding mechanism where the buck stops with the landowners. They agreed that if the improvements cost more money, that additional debt can be placed on their land, and they just haven't paid. That places us firmly in the category of cases where the owners have not paid anybody for the work, and in which the contractor does have a claim.
With that judgment that was obtained, is there a lien on the property?
No, I don't believe there is, because it's government property. I'm not 100% sure on that. I don't think that's in the record, but that's my current understanding.
I'm assuming the district doesn't own the land.
The district does not own the land. The district is essentially just a government entity that is designed to benefit the real property owned by the landowners.
An aside, so we look at the landowner creation of the district contract, and it says no liability will flow. We look at the agreement entered into the district by the district and your client, and it basically has no recourse against the landowners. When a bank advances money, they make sure they have proper security. Wasn't your client under some sort of obligation to ensure that he had the security necessary for them to satisfy his bill?
No, Your Honor. So, and again, that kind of argument could have been made in any of the cases like Flooring Systems or Murdoch Bryant or Constanzo. You always potentially could have found additional security. But the unjust enrichment doctrine does not require you to have done so. It is an equitable gap-filling doctrine that is designed to avoid exactly what it says when someone is unjustly enriched by receiving benefits that it should have paid for but didn't. And so those contractual limitations on liability don't preclude an unjust enrichment claim because we're not suing on those contracts. We're suing for the benefits that they have received. It doesn't force someone to become a guarantor or anything like that. And they always expected to have this liability. The assessments unquestionably are a liability on their land that already should have been paid, and they have not paid it. So we're not imposing any liability that they did not expect to incur, that they did not voluntarily take on. It's the same as, again, in those cases like flooring systems, where you have a contract between the owner and the general contractor, a contract between the general contractor and the sub, and those contracts almost always have the same kinds of limitations Your Honor is talking about. These construction contracts are standard contracts. They all have this language. But those limitations do not preclude the contractor from going after the owner when the owner has not paid what he owed to the intermediary. And that's the key thing here, is that the third party is an intermediary here, like in all of these cases. And if the money has not gone from the owner to the intermediary, you're not imposing any liability that they did not already expect to have. And the doctrines that get at this are whether they had an understanding that they would be free from this obligation. It's not that they had a contractual responsibility to pay. It's the opposite. It's did they have an understanding that they would be free from this obligation. And I have an example that I'd like to give you in the context of like a wedding, right? And so you're getting married, you hire a wedding planner, and the wedding planner hires a band. If the couple getting married doesn't pay the wedding planner, and the wedding planner then doesn't pay the band, and in this hypo, the wedding planner actually engaged the band, this element that there was an understanding that the parties would be free from the obligation means that there's no unjust enrichment claim against the guests of the wedding who received a benefit, right? They got the beautiful music at your wedding, but you don't have an unjust enrichment claim because there's an understanding that guests at a wedding are free from obligations of paying the band. That understanding is not present with the couple getting married, because the understanding is that the couple getting married who told the wedding planner, hire a band, and the wedding planner hired the band, we don't expect the couple to be free from this obligation. Even if there's no direct contractual liability there, there's an unjust enrichment claim because they did not expect to be free from the obligation.
I realize you probably want to reserve time, but
I do.
We'll give you a couple minutes. Well, maybe. I get that the difference, presumably, between guaranteeing and the unjust enrichment. So you're not guaranteeing the contract. It's the unjust enrichment. Kind of a weird hypothetical. Does the landowner get to relitigate the actual benefit? They've said they weren't paid for this, but if they can come in and say this did not in fact benefit my property at all, do you relitigate that, or is that fair game if this goes back to say I really wasn't benefited, so I don't have to pay for whatever reason they don't think the work
Right.
actually benefited the.
Yeah, I understand the question. I think in the abstract, the answer is probably yes, because the measure of damages might not even be the same between an unjust enrichment claim and an arbitration on a construction contract. I don't know whether there would be difficult questions about collateral estoppel or res judicata. I don't know. Those aren't before the court. I think in the abstract, yes, if the party can mount a defense and say, this did not in fact benefit me, or this did not benefit me to the extent of the judgment, those may be viable paths. Here I think that's going to be difficult because, again, in the development agreement, the landowners expressly acknowledged that this work would benefit them in an amount not less than the value of the assessments on their land. So that's probably going to be Exhibit 1 in our case. But I think conceptually that's right. And I appreciate your offer to give me additional time. I hope Judge Campbell agrees with you. And I'll reserve the rest of my time for
I'll
rebuttal.
agree with you, not him.
Thank you.
Thank you. Can we add 3 minutes to both sides, please? Let's get it on there before you start.
All right.
You got 6 extra. You ready? Please proceed.
May it please the court, Timothy Berg of Fenimore Craig on behalf of the defendant appellees who I will refer to as the property owners. Mr. Frazier starts by discussing the third restatement with you, and I would suggest to you that the court's analysis here ought to begin and end with a Wang case. The third restatement is really beside the point. I can address that later, but let's talk about Wang first. Because you have an opinion of the Court of Appeals, of this Court of Appeals, which sets out the principles that govern here. What Wang Electric Court made clear is that there's a general rule that when a non-owner contracts for improvements to the owner's property and then fails to pay, the owner is not liable to the contractor or the supplier unless he agreed to pay them. In reaching that rule, Wang relied on Section 110 of the first restatement, restitution, which says, a person who has conferred a benefit upon another as a performance of a contract with a third person is not entitled to restitution from the other merely because of the failure of performance by the third person.
Merely because seems pretty weight-bearing. They're not saying it's merely because. They've given a whole bunch of other reasons.
Most of which are not alleged in their complaint, Your Honor. That was going to be my second point, is to take you back to the complaint and look at what they actually allege. A good bit of what's talked about in their briefs and talked about this morning really isn't what's alleged in the complaint. If you look at the first amended complaint.
What's the reason for not allowing the second amended complaint? I understood the court's ruling to say it would be futile, but is your position the same as to the proposed amended complaint, that there's nothing in there that alleges something that gets them there under
Yes.
the first restatement?
Yes, Your Honor. There is nothing that alleges wrongdoing by the property owners. And that's what they had to allege.
I read allegations that the property owners didn't issue assessments because they would just be paying themselves. It made it look like there was certainly a whiff of their engaging in, they're not imposing the fees because they don't want to pay them themselves. It's the same person.
The 2 points there, Your Honor. First one is, if you go look at the statute that creates these districts, and I think it's 486802C and maybe D, the directors of the district have to be landowners in the district under the statute. You can't have a separate board of directors. There's always going to be an identity between the landowners and the board because the statute requires that.
But this is a very closely held district, like a closely held corporation. Explain to me the corporate structure and who all is involved, because that wasn't as clear as it could have been in the briefing.
Yeah, and it may not be clear in the record, Your Honor, so I'll do the best I can trying to stay with as much within the record as I can.
I will appreciate it.
Essentially, there are a series of entities, limited partnerships that own land. The directors of the district included people who are officers or members of those limited liability companies or limited partnerships.
So I think there's 4 from what I gleaned.
For landowners, yes, Your Honor.
Okay, and of those landowners, how many actual people are involved in those 4 entities?
I don't think that's in the record. I don't know how many owners there are, how many partners there are. There are 3 people on the board who came from those companies. That I can tell you is in the record.
But we're not talking about, typically these improvement districts are 400 landowners come together, or an entire subdivision comes together consisting of individuals. This is 4 separate entities run by 3 separate people, but we don't know if there are different landowners that actually own the dirt.
Yeah, there's nothing in the record on that, Your Honor. The answer is, I think that...
I'm glad I didn't miss it.
No, you didn't. One of the challenges here is we're dealing with motions to dismiss and complaint, so I can only answer what's in the complaint and what's in the record.
Let me give you a different hypothetical,
Okay,
though.
certainly.
Let's say the district had issued the assessments,
Right.
and the landowners just say, we're not going to pay.
Okay.
Is there a claim for unjust enrichment?
No. The district has a claim against them to collect the assessment. Markham has a claim against the district for breach of contract.
But why haven't they been unjustly enriched? If they received the benefit of this work that they had said, we're going to pay, it seems pretty clear under the third restatement that it kind of lays it out.
It doesn't, Your Honor. I think if you were talking before about section, I think, 2.4 of the restatement, third, which talks about an innocent party, and I think that's the equivalent of the wrongful conduct here.
Yeah, and there's no innocent party in just in the language under the third restatement, but it just says is one for which the defendant has expressed a willingness to pay. You agree that aspect was met here?
Yeah, it expressed a willingness to pay not to Markham, but to the district.
Right, but they're getting something that they're willing to pay for, and it saves them an otherwise necessary expense. That seems
But Your Honor, if you follow their argument, then Wang has to come out the other way. Because in Wang, the landlord gets the benefit of the improvements that the tenant didn't pay for when the property is over. The only way to get where they want to
express a willingness to pay in Wang?
Yes, in fact, I believe he approved it and expressed a willingness to pay for at least part of the improvements.
But that's a difference. Here, they've expressed a willingness to pay for everything, have they?
Well, I don't think I think it's a distinction without a difference, Your Honor. I think if the question is, did the landowner express a willingness to pay under the restatement? Then in Wang, the landlord had expressed a willingness to pay, and in fact was approving, I think, the drawings and stuff.
Were they? I don't remember the specifics in Wang. Was it just a general? I'm on board with you doing some things, or is it?
No, I think in Wang it's even a different situation than here. And I'm sorry. I believe the landlord approved the design. He actually even approved the payments that the tenant was making to the contractor. And again, Judge Timmer found that that's not enough. If you want to hold the landlord, or in this case, the property owner's liable, you have some options. One, as Judge Campbell suggested, you could get a guarantee. You could take some kind of security. Markham's here because they didn't do that in their contract. If they had insisted on a guarantee from the landowners, they would be here.
They're not making a claim as a third-party beneficiary of a contract. They're just saying they were unjustly enriched.
But Your Honor, they weren't, because there's no wrongful conduct. What Judge Timmer's opinion, Justice Timmer, pardon me, his opinion, then Judge Timmer's opinion, let's do it that way, in Wang tells you is that in a situation where a contractor contracts with a tenant, with a district, with a third party, and that third party doesn't pay, it isn't the obligation of the landowner to pay in unjust enrichment or in contract.
Did the person who is contracting have some knowledge that the owner of the landlord was going to pay when they contracted with the tenant?
I think the answer is they had the same sort of arrangement they had here. The landlord had agreed to pay part of the sum.
Part of the sum. That seems very different than when you have the whole point of forming the district is we're going to pay for everything, including overages. Isn't that different than landlord's going to pay part of it? That doesn't tell me exactly what I can expect as the person doing the work.
Well, but the point is that the person doing the work isn't relying on that. They're undertaking a contract with somebody. In the case of Wang, they have a contract with the tenant, and it's the tenant they're looking to be paid. In this case, they have a contract with the district, and it's the district they're looking to be paid. The district and the property owners are separate entities. If you go down the road they want you to go down, then there's never going to be a difference between the district and the entity, and every case like this is automatically going to put property owners. The property owners may as well guarantee the contract because they're going to get sued in unjust enrichment anyway, merely by virtue of being property owners in the district. Again, we took this.
Isn't there the difference? That's where I was trying to go with Mr. Frazier. If the work you did didn't actually benefit the property, they thought it was ahead of time, the district contracted to do something, and it turns out it didn't end up conveying a benefit, then they don't have you can't claim unjust enrichment. If for whatever reason it didn't work out the way that it was anticipated to actually be a benefit. So they're not guaranteeing the contract. They're just.
But I don't think that's what Wang says, Your Honor. I don't think Wang says you get out of an unjust enrichment claim if you didn't in fact get enriched. I think in Wang there was no dispute that the Smoke Tree, I think was the name of the resort, premises had been improved by the contractors, by the electric company, the roofing company. What Judge Timmer said, then Judge Timmer said in Wang is that we don't impose liability, contractual or quasi-contractual, on people who don't agree to take it unless they've done something improper that makes them a proper subject. What could they do? They could have, if the landowners had said to Markham, don't worry about it, the district doesn't pay you, we'll pay you. Sure.
So I
If the
want you
landowner-
to accept this premise. If what you say is true, then any revitalization district could enter into a contract with a third party and never be responsible for paying for them. And when we look at 486808, nobody can force the district to assess the levies under subsection E. They don't have the authority to compel the district to make the assessments or do the collections. So should contractors simply never contract with a revitalization district?
I have a couple of different responses to that. Now, let me start with the first one, which is, of course, they have a judgment against the district. They have a pending mandamus action against the district in the Superior Court, which we asked the court to take judicial notice of, where they're trying to, by mandamus, force the district to make the assessment and collect it. So it is not at all clear here in this case that they can't get the money from the district. I think if I were a contractor and I were going to contract with the district in these circumstances, I'd make the property owners guarantee the contract or I wouldn't enter into it. That's hindsight's 20/20, I suppose, but that's certainly the prudent course. If you want to have somebody on the hook besides the person you're contracting with, whether it's a district or anybody else, you ought to make them a party to the contract.
What I'm taking from the pleadings is they've dismissed the individual defendants, but would you, and it seems to me in your pleadings, you're suggesting that any wrongdoing was on behalf of the district, that the people for failing to issue the assessments. So, but that seems like a pretty fine line to draw if these people are not only the district, but they're also landowners. How can we say they're not acting on behalf of the landowners when they decide not to issue the assessments?
Your Honor, I'm an attorney at Fenimore Craig and I am a member of the Arizona Uniform Law Commission. When I act on behalf of the Arizona Uniform Law Commission in going out to the legislature and lobbying to pass laws, I'm not acting on behalf of Fenimore Craig.
Okay, but how about if you...
We have entity law to create separate entities like partnerships, companies, districts for a reason. And that's to separate things and to have the
You're wearing a
actions of
different
them.
hat, I understand that,
Okay.
but when you put on your other hat as a landowner and you tell someone wearing the hat of being on the district board, don't do something, isn't that wrongful conduct by the person who's wearing this different hat?
And there is nothing in the complaint that says the property owners told them not to collect the assessments. What it says in the complaint is these two people who were on the district board didn't assess the property and didn't collect it.
In the amended complaint.
In the amended
second
complaint, yes,
It
yes.
seems to me it got pretty close. It said they didn't do it because they would just be collecting from themselves and they didn't want to collect from themselves, or am I reading too much into that?
I don't think that's exactly what it says, Your Honor, but even if it did, it doesn't matter because, again, the actions you're talking about are the actions of the directors of the district. The property owners don't assess. The property owners don't collect. The district assesses, the district collects. And if there's a failure to assess and a failure to collect, that's a failure of the district, not a failure of the property owners. And the fact that the statute requires that those two people be the same doesn't change the fact that they're separate entities and people acting in different roles. If we had a statute which said, for example, the Judicial Council has to consist of the Chief Judge of Division I of the Court of Appeals, I would suggest to you that there's still a difference between that judge acting as a member of the Judicial Council and acting as a member of the Judge of the Court of Appeals.
Well, I understand
because those are different roles.
But when we're looking at an equitable doctrine like unjust enrichment, it seems like we can look to the fact that this person is essentially controlling it in their other capacity as a landowner and saying, don't send us a bill.
No, I don't think you can, Your Honor. I just don't think that. I think that if what you're saying is true, then in no case where there's a district is there going to be a the landowner is not going to be liable. And essentially what you're saying is anytime landowners form a district and the district contracts to have work done, the landowners may as well guarantee that contract because we're going to hold them liable in unjust enrichment if they don't. And that's the same as saying in a way.
If the district can, if the
district
contractor can
doesn't
show that they were actually benefited.
And if the district doesn't assess and collect, but it's the district that doesn't assess and collect. I don't think there's wrongful conduct, but if there's any wrongful conduct here, that's what it is.
Can I ask you on just your view of the third restatement? Is there any reason for us not to go with the third restatement? I'm not seeing that it's inconsistent with the first restatement. Am I missing something?
I think, Your Honor, first of all, my understanding is that this court looks to the restatement and adopts it where there's no Arizona law on the point. And my answer to that first would be you have Wang. And Wang tells you what you need to.
So we wouldn't limit, you're saying Wang applies beyond the landlord-tenant context?
I think if you go back to the quotes I read for you from Wang itself and from the restatement at the start of this, they don't talk about landlord-tenants.
But I guess
the restatement talks about a person who has confirmed a benefit on another as a performance of a contract with a third person. That's this situation. That's other situations. That isn't just landlord-tenants.
But you do agree there's a little bit of a difference when there's not a promise ahead of time to pay the entire bill. It's just I'm on board with the landlord doing some improvements compared to a situation where somebody says, we're going to form a district, we're going to pay for all the improvements. That's the point of forming a district.
Your Honor, remember in Wang, while Smoke Tree was only paying for part of the district, they approved the whole contract for everything. They reviewed the work as it was being done, and they were paying at least their part of the process payments. I think Wang has more involvement by the landlord in the construction activity and what the tenant was doing than this case does. Here, the contract Markham had was with the district. It wasn't with the property owners.
So you're just saying Wang is inconsistent with the third restatement?
To the extent they argue that the third restatement leads you to a different result than Wang, and we disagree with that because of Section 2.4's discussion about innocence. We think innocence is the same thing as an absence of wrongful conduct. But if you read it as being something different than Wang in the first restatement, yeah, then it's inconsistent and the court should follow Wang in the first restatement. It seems to me that simply the fact that a bunch of lawyers and law professors sat in Philadelphia and rewrote something isn't a good and sufficient reason to change a well-reasoned decision in Wang.
Just reading through, it's hard to take much issue as I just read the third restatement as fresh and understanding the first restatement that just says merely because. It doesn't really flesh that out at all. This seems like a pretty logical fleshing out, and in fact it narrows a little bit since merely because opens it up to a world of other possibilities. Here this sort of narrows it, and they seem like reasonable conditions. One for which the defendant has expressed a willingness to pay. You don't disagree with that? They did express a willingness to pay.
Yes, Your Honor.
And it saves the defendant.
Again, to the district, not to Markham.
Right, yes. but they got a benefit that they were willing to pay for, I think is the whole point of unjust.
Your Honor, I'd like to answer your question. There's a part of the third restatement, Section 2.4, that I think you need to look at. You've looked at it because you asked a question about it before, but I want to be sure we cover this. It says, liability and restitution may not subject an innocent recipient to a forced exchange. In other words, an obligation to pay for a benefit the recipient should have been free to refuse. That principle, which carries over into 23 that you were talking about, means that an innocent party, like the district in this case, can't be made to pay. That's consistent with the Wang rule that says my client has to pay if it's done something wrong.
An innocent party.
You talk about innocent party, and we have got the landowners agreeing to the assessments that will be assessed by the district, the landowners agreeing that they are going to receive this benefit under their district creation document. So when you talk about an innocent party, they knew the contract was going to happen, they knew they were on the hook for the money. How do we then say that it's like the guy that comes by and mows your lawn when you're not home and then hands you a bill?
It's not like the guy that comes by and mows your lawn, but Wang's not like the guy that comes by and mows your lawn. In Wang, the landlord and the tenant agreed that there would be improvements. They agreed the landlord would pay for part of it, the tenant would pay for part of it. They agreed that the process would go on. And again,
but I beg to differ that it's just like Wang, okay? Wang, we have a property owner, Smoke Tree, and they own this commercial space. Tenant has some things they want, landowner has some things that are required, sprinklers, safety equipment, etc. The tenant improvements may or may not benefit the landlord. It may be building out a kitchen for their business, building out this or that. So their interests are not aligned the way landowner
But Your Honor,
and district are.
Wang doesn't reject unjust enrichment because the landlord didn't benefit. The analysis you just said would be absolutely correct if what Wang said was, we're finding that the landlord isn't responsible for these tenant improvements because they didn't benefit the landlord. But that's not what Wang says. What Wang says is we're finding that the landlord is not responsible for these improvements because he, it, she, whatever, didn't agree to pay for them and hasn't done anything wrong, such as representing to the contractor they would be paid for them. And that's different.
When we look at the assessment, and hypothetically, okay, I'm wearing my landowner hat. Don't make the assessment to myself. Self, I change my hat. I'm the district. I'm not going to make the assessment because you're telling me not to. I mean, this is a 12B6 motion. Shouldn't we get to the bottom of who was the improper actor here, if there was one?
No, I think they have to allege sufficient unlawful conduct on the part of the property owners, and they haven't done that either in their first complaint or in the second amended complaint, which they weren't permitted to file, Your Honor. It's all well and good.
Speaking, had they said, Mr. Stapp, as a landowner, exerted improper pressure on Mr. Stapp, the director of the board of the revitalization district, that'd be enough?
I don't know that it would be, but you don't have that here, so it's easy to say there's not enough here in this complaint, Your Honor.
Okay.
You're getting closer, there's no doubt about it. If they, let's say, for example, the landowners went in and fired the whole board and replaced them with somebody else's, there are all sorts of possible, the easiest example would be if they had gone to the landowners and said, we're worried about the district being able to pay us, will you stand behind it, or do we have to worry about that? And the landowners had individually said to them, don't worry about it, we the landowners will stand for it. That would be the kind of conduct they need. What they don't have here is action by the property owners on which makes it unjust for the property owners to be in the position they're in. I have all of 50 seconds left, so all I will ask the court to do is affirm the judgment below. Thank you all very much.
Thank you.
You're fine. Your Honors, improper conduct is one way to satisfy the elements of unjust enrichment, but it's not the only way. And it is, I think, inconsistent with the general doctrine of unjust enrichment, which is not about wrongdoing. A word about guarantees. Section 25, the comments, say, and this is obvious, but they say that when you're in this scenario, things have not gone according to plan, right? I mean, again, you look at all of these cases where you have this scenario, things have not gone according to plan. You always could have sought a contractual guarantor. Here, our counterparty was a government entity with the taxing power and the power to levy assessments against real property. You shouldn't need a guarantee when your counterparty has the taxing power of the state. The situation we have here is that it is so overlapping, complete 100% overlap, that they've become untrustworthy. And a word about different hats, because I think that concept that Mr. Berg used is a good one. We are on a motion to dismiss here. And so we don't know on whose behalf these people are acting on. We don't know which hat they were wearing.
We do. They're landowners, and they're also controlling the board.
Well, right. And so that is, when we're on a motion to dismiss, the court has to draw all inferences in our favor. When we allege that Mr. Stapp did something, and he wears two roles, a reasonable inference is drawn in our favor is that he was acting at least in part on behalf of the landowners. And we're entitled to conduct discovery and ask Mr. Stapp in a deposition, did you consider the effect on the landowners when you decided not to collect the assessments on the district? And again, that's only if we need to show improper conduct, which we don't, because Section 25 is getting at this concept of a forced exchange. It says, it references to Section 2.4 in the text of Section 25, and says in this context, to show that there is not a forced exchange, you have to show one of the following three things, and there are a bunch of items with subparts. That is really where the court can rely. And if you look at Section 2, again, we talked about this earlier, Comment E in Section 2 of the third restatement, Comment E of Section 2 of the third restatement is called forced exchange. And the example it gives is it's not the exact one, but it's the one I gave you of mowing a lawn and then giving someone a bill. That's the concept you're trying to avoid. You're not trying to avoid an unjust enrichment claim against somebody who set the whole thing in motion, detailed out to the penny in the district agreement that the landowner signed. If you look at the attachments there, it detailed which work was supposed to be done and how much it would cost to the penny. And then they explained how that would be paid for. They allocated it among individual lots. They have pages and pages of APN numbers, the county property tax numbers. They knew that they would have to pay. They knew that they would ultimately be responsible for paying, and they just haven't, which is why ruling in our favor will not have the terrible consequences that Mr. Berg suggests, because this is a flexible, equitable doctrine, and courts know how to differentiate between viable claims and not viable claims. This will not subject, residents of the city of Phoenix to be responsible for municipal debt. This is a 4-entity district with the same people, the same person is the president of all 4 entities, of each of the 4 landowners. This is not a broad community benefit. And one last word before my time is out. The first restatement, as Judge Catani recognized, says the word merely. That bears a lot of weight, but it doesn't explain how to differentiate between viable and non-viable claims. The third restatement does that work, and the court should adopt it. We ask that you reverse. Thank you, and thank you for the extra time. I appreciate it.
Thank you, gentlemen. We appreciate your arguments today. We will take this matter under advisement, issuing a written ruling in due course. We are at recess.